Good morning, everyone, and welcome to this ENSafrica webinar, where our speakers will discuss the impact of the Protection of Personal Information Act, also known as POPI or POPIA, on mine health and safety. We are extremely excited to be hosting this webinar and wish to thank you all for your attendance. Our speakers will be discussing a very important topic, but we all reflect that this is during a time in which our beloved country is confronted by COVID-19 and public unrest. My name is Peter Kulain, and I'm privileged to be an executive of and the head of the ENSafrica's Mine and Occupational Health and Safety Department. It is a real honor to introduce our three speakers to you in the order in which they will present today. Firstly, Nicole Gabrick, who is an executive in ENSafrica's Dispute Resolution Department. Secondly, Ira Gunning, who is an executive in ENSafrica's Banking and Finance Department. And thirdly, Willem Leroux, who is an executive consultant in ENSafrica's Mine and Occupational Health and Safety Department. Nicole has specific experience in and knowledge of data protection and cyber-related risk matters. She has written a number of articles on data breaches and how to react to data breaches. Ira advises regularly on consumer and data protection. She has been quoted in various media publications as a POPI expert and has also authored a publication on data protection. Nicole and Ira conduct regular webinars and are currently involved in various matters dealing with POPI. Willem, our third speaker, is a highly experienced and widely recognized specialist in mine and occupational health and safety law. He has successfully acted in several large and extensive litigation matters, high-profile inquests, accident inquiries, and criminal prosecutions. He is the author of a number of publications, including the authoritative Mine Health and Safety Law publication. Nicole and Ira will first deal with various general and specific aspects of the Protection of Personal Information Act. Willem will then deal with the impact of the Protection of Personal Information Act with specific reference to various provisions of the Mine Health and Safety Act and the Promotion of Access to Information Act. They will all provide legal and practical perspectives during their presentations. The speakers will make use of a PowerPoint presentation, and this PowerPoint presentation will be emailed to all of you after the webinar. If you have any questions, we propose that you post them in the chat box, and the speakers will attempt to address these questions during their presentations. We will attempt to conclude the webinar around 10 o'clock this morning. With this, we will then start with Nicole and with Ira. Over to you, Nicole.
Thanks very much, Peter, and thanks everyone for joining us this morning. We're going to do a little bit of a quick POPI 101, so to say, just to go over some of the basics and just to put some of the concepts in our mind again. And I'm sure many of you are bored to death with some of these aspects already, but please bear with us, and hopefully there's some learnings that we take out of it. So what we're going to look at now is just a POPI 101 overview of some of the first concepts. So the first thing we need to know is when POPI came into effect, and I'm sure the 1 July date is ringing loud and true in everyone's ears, and we expected a Y2K kind of scenario, and the world didn't fall over on 1 July when POPI came into effect. But by and large, POPI is now fully in effect, save for one minor provision dealing with prior authorization, which has been delayed until next year. I'm just trying to move the slides, and for some reason they are not moving on my end. Let me just do that. There we go. So the first thing we need to remember is that POPI is really going to regulate this concept of a responsible party. We'll touch on again what that means, but really a responsible party is the party who determines the purpose of the processing of personal information. So when is POPI going to apply? Remember, every entity within a group is its own responsible party vis-a-vis its personal information. So because we've got a group structure doesn't mean that just the head of the group is going to need to comply. Remember, the entire group structure, each subsidiary within that group needs to comply with the provisions of this act as well. So really what we're going to look at is the processing of personal information, which is when POPI is going to apply. Remember that it's automated or non-automated. Again, think about the fact that POPI doesn't just apply to the digital era. It doesn't just apply to what we do on our PCs or on the cloud. The physical paper that we work with is equally important when it comes to thinking about POPI compliance. The next thing is that it needs to be entered into a record. So the discussion that perhaps we're having here between you and I, that in itself wouldn't necessarily constitute processing personal information. So if I say to you, Willem is an excellent practitioner, that in itself is giving an opinion, and I'll tell you now why that is personal information. But once we capture it into a record, so we click record on this, we write it down, we put it into some sort of record, it's then in the ambit of POPI. So it's not just the discussions we have, it must be in a record. What does then tend to create a bit of confusion is when it applies. Now, distinctly different from GDPR, which is the European privacy legislation that many of us are familiar with. It doesn't matter whether or not the information is about a South African resident or citizen. It does tend to create confusion. People think that must be how it applies because that is almost invariably a trigger under GDPR. For us, it's whether or not you are domiciled or process that information in South Africa. So very briefly in a minute, what is processing? Processing is pretty much any verb you can think of when it comes to personal information. Anything you think you can do is probably processing. So not just receiving information, not just collating information, not just sending or storing, but also where we delete or erase personal information. That is also processing personal information. So please be very mindful of the fact that anything we do with personal information from 1 July is likely to be processing. And we must bear that in mind when it comes to what ERA deals with shortly, which is the processing conditions. Right, then we need to turn to the concept of what is personal information. Now, personal information is distinct from confidential information. While personal information and confidential information, as we think of, can overlap, we mustn't confuse those concepts. So the first thing we need to know about personal information, our first very important concept, is that it relates to an identifiable person. Now, the concept of person is not limited to human being information. We are the only law in the world that certainly that ERA and I know of, and if anyone else picks up on another law that extends as far as ours, we'd be very willing to debate it. It also extends to juristic persons or company or corporation information. Trusts and companies and suppliers and vendors and all those sorts of people we work with, they are also identifiable persons for the purposes of POPI. And so we must remember that their information is also ring-fenced and protected by this act. Now, we often get to the concept of when do we need consent? And people tend to think that if you've got consent, you're POPI compliant and you can charge ahead. Consent, and as we'll demonstrate with the understanding of personal information, when ERA talks through the processing conditions, consent is a golden thread, I like to say, that helps us comply with the act. But it's not a silver bullet. It doesn't give us all the answers we need. Why is that important in relation to personal information? Because on the screen in front of you, you'll see two colors. There's black and red. The black information is our general personal information. And once again, our general rule of thumb for the black information on the screen is that we do not need consent of the data subject in order to process this personal information. But where we come to the red flag information, that is called special personal information. And we have to be extra careful, and that red flag needs to go off in the back of our minds, because that is where, as a general rule, we have to have consent. There are some exceptions, and I'll touch on those in a minute. But just looking at the kinds of information on the screen in front of you, you'll see that it's quite broad. And you'll see in the fullness of time, you're welcome to look at these slides. We've contained the definition of personal information and special personal information in these slides, if you want to reference back to them. But where we touch on issues is trade unionship membership, okay? That is something we deal with on a day-to-day basis. Race or ethnic origin, we deal with that on a day-to-day basis. Health information, if we think about our COVID stats and injuries on site, these are all things where we're going to touch on health information. Alleged commission of criminal offenses. And I'm not talking actual convictions, I'm talking alleged, so doing investigations into people's conduct. These things are all special personal information. Now, our first rule, I said, is you have to have consent. And if we turn to section 27 of POPIA, we'll see some other carve-outs, okay? So if we don't have consent, and consent is not always obtainable, and particularly when we look in the employment space, for example, under GDPR, they don't like you obtaining consent from employees. They tend to say consent by employees is not obtained in an equal bargaining position. But in any event, if we can obtain consent, that's first prize, and we move forward with that. So what if we don't have consent? Our next thing is, does the law obligate us to process this information? So injuries, BE information, COVID health information, there's all pieces of legislation that force us to process this kind of information, which we then do. But there are other things as well. So have a look at this on the screen, have a look in the fullness of time and say to yourself, do any of these other exceptions apply, and can we rely on them? Right. This is just the last item I think that I'm going to deal with is, again, children's information. Remember, information of children is personal information on steroids. Really, we need to say to ourselves, we do not touch children's information unless we've got consent. And again, there are some very specific carve-outs, but we need to just be very mindful of that.
Perfect. Thank you for that, Nicole. And I know our slides were freezing a bit there, so we've been trying to operate each other's slides. I hope mine is working now. But yes, I'm going to look at the 8 processing conditions. Now, these are the heart of POPIA. So first of all, when you're trying to check whether POPIA applies to you, you check, like Nicole said, whether we're processing personal information which is entered into a record. So where we are now processing personal information which is entered into a record, like we all do, then we have to comply with the heart of POPIA, namely the 8 processing conditions. Now you have to comply with all 8. You can't just nitpick 1 or 2. You have to comply with all 8 conditions of processing. And if you are dealing with red flag information or special personal information, then your life becomes a little bit harder. Then you generally need consent, or you could rely on one of the other exceptions, like you're doing it in terms of an obligation of law and so on. So the first condition is accountability. Accountability says comply with POPIA and be able to show you comply with POPIA. How do we show compliance with POPIA? We, for example, have a POPIA policy, a data protection policy. We have a POPIA compliance framework. We do training and awareness. We make sure we've got an information officer, and so on. The next 3 processing conditions go hand in hand. So processing conditions 2, 3, and 4 go hand in hand. You always need to have a specific purpose before you process somebody's information. But this purpose must be lawful. So you have to have a lawful justification for processing that information. So my purpose can't be, I'm a hacker. My purpose must be mining health and safety, or giving effect to a contract of employment or procurement. But we must have a specific purpose. And then we have to identify what is the information that we need to fulfill this purpose. We mustn't excessively process information. Don't ask for stuff you don't need. If you're assessing a person's health, you don't need to look at their gender or their sexual orientation or their sex life unless you can show it is specifically linked to your purpose. So identify what information you need and only collect as little information as you possibly need. Now, you've got your purpose and you've got your lawful justification, and we'll look at the various lawful justifications in 2 minutes. They include consent, but they could also be things like legitimate interests. So you have collected your little bit of information. Now you're going to store that information. Only store that information for as long as you are authorized to store that information. When are you authorized to store that information? You're authorized if you've got consent, or if there's a law that says you must, like the mining and health regulations and legislation, which Peter and Willem know a lot more about than Nicole and I, or if you've got a lawful business reason. So if you've got a lawful business reason, you can also keep and record that information. So POPIA doesn't say destroy or delete information after a year. It gives you various reasons to record and store that information. But when you are no longer authorized, at that point, you have to delete or de-identify or anonymize the data. It's so important to have a record retention policy that sets out rules for the storage of information. And then a very, very difficult condition is condition 4. So condition 4 says, you have now collected this information for a specific purpose. Everything that you do with that information going forward in future must be compatible with the reason why you collected the information in the first place. Don't collect information for COVID tracing purposes and use it for direct marketing afterwards. Don't surprise the data subject with what you are going to do with that information in future. And this is where a personal information sharing policy comes in very handy, and also a privacy policy or privacy notice where you tell people what you're going to do with the information and where you tell companies what you're going to do with the information. The next 4 processing conditions. Condition 5 speaks to the quality of our information. We need to take reasonably practicable steps to make sure all the information that we have in our possession, including health information, HR information, old CVs and the like, is complete, accurate, not misleading and updated. POPIA doesn't tell us what to do to keep this information updated. It just tells us we need to do something. Then condition 6 is openness. Openness says we need to tell the data subject certain things. We need to tell the data subject who we are, what information we collect, why do we collect that information, who do we share that information with, do we send the information out of South Africa, and we even have to tell them that if they want to fight with us, they can go to the information regulator with the contact details of the information regulator. Security safeguards. Nicole, I know this is your field, cyber insurance, cyber attack, security. Do you want to speak to that a bit?
Just to say the following. Remember, POPIA doesn't tell us how we need to look after our information. It does tell us that we do have to look after it and implement these measures. But so importantly is that we need to remember that when we look at what a data breach means under POPIA, we need to match it back to say, are our security safeguards good enough to prevent that sort of issue? Now, data breaches are so widely defined under POPIA that they cater for any instance where an unauthorized third party may have accessed or acquired your personal information. So take, for example, you're driving home and you've got a file of papers in your car and you stop and get a Red Bull to get through this POPIA seminar. And in the crux of that, somebody breaks into your car and steals that paper. Now, that in itself would constitute a data breach. So you have to really think through not just your technical measures. So do we how do we encrypt devices and how do we look after that information? We all saw our president lose his iPad on national TV the other evening when it was forcefully displaced from him. These sorts of things happen all the time. Accounts are compromised. Ransomware attacks happen. These things are happening on a daily basis, and it's happening all the time. And we really need to say to ourselves, how do we look after this information to prevent this so that we don't have a need to report and fix a problem further down the line?
Absolutely. And with the looting in South Africa, where your hard copies of documents are being compromised, that likewise would be a data breach. But we found that about 80% of our data breaches happen because of our employees. And it could often be because of training and lack of awareness. For example, using the CC, where you are supposed to use the BCC on emails and so on. Condition 8, data subject participation. So data subject participation gives our data subject certain rights. They can come to us and say to us, what information do you have about me? Where did you get that information from? Who did you share it with? And then worst case scenario, they can even exercise their right to be forgotten. If we are no longer authorized to have the information, they can ask us to forget about them altogether. A subject access request policy comes in very handy, and a POPIA manual is a must. The difference between subject access requests in terms of POPIA versus POPIA requests would be the following. A subject access request is, I want information about myself that affects my rights, it's my information. A POPIA request is, I want information about a third party that affects my rights. Now, just now, when I spoke about having to have a lawful justification for meeting your purpose. So your purpose could be wanting to employ somebody, procurement, checking health and safety, implementing health and safety. But then we must always check, do we have a lawful justification to meet our purpose? Now, one lawful justification is consent. And I like relying on consent when we are dealing with the red flag information that Nicole was speaking to in the beginning. But we don't need to have consent when it comes to the ordinary personal information. When it comes to our ordinary personal information, we could also rely on, we are carrying out actions for the conclusion or performance of a contract. We can say we're doing it because there is an obligation in terms of law that tells us we must do it. We can even do it because it's in the legitimate interests of the data subject. By the way, under the GDPR, they speak of vital interests. And there we think maybe there's some sort of health and safety aspect to it. But POPIA speaks of legitimate interests of the data subject, or the legitimate interests of the company itself, and these could include commercial interests, or the legitimate interests of a third party, such as a business partner. So there are quite a few excuses if you don't have consent to process our ordinary personal information. But of course, red flag information, stricter when we deal with that. Generally, we need a law or consent unless, for example, the information was deliberately made public. So if you are going to rely on consent, you are going to have to prove that you did in fact obtain consent. So even though something like verbal consent would be valid, it may be more difficult to prove. Also remember, the data subject can always withdraw their consent. Again, Nicole touched on this. This is why the GDPR doesn't like consent in the employment relationship. But even if our data subject, like our employee, withdraws their consent, we can still rely on one of those other backup exceptions to consent, like legitimate interests, or there's a law that says we can. Also bear in mind, if we rely on legitimate interests or proper functions of a public body, which I didn't touch on just now, the data subject can object to that as well. Just because they object doesn't mean we're going to have to stop that, but they can object, and then we can decide whether our interests outweigh their interests, and this fight can land up in front of the regulator eventually. Bear in mind, they cannot object to you processing information in terms of a contract or in terms of a law. It's generally the legitimate interests that they can object to, and they can withdraw their consent. And then jumping ahead to the notification requirements, which I dealt with when I dealt with the openness condition. We need to tell the data subject certain things. We don't want our data subjects to be surprised by what we do with the information. So we need to take practicable steps. And we like doing this, for example, in the likes of an internal privacy policy for employees and external privacy policy for outsiders, which could be placed on a notice board or your intranet or SharePoint, where we tell the data subject what information we collect, why do we collect it, who do we share it with. But please note, we don't always have to make those notifications. For example, we don't have to comply with the notifications if non-compliance would not prejudice the legitimate interests of our data subject. Or we're doing it because a law tells us, we're processing the information because a law tells us we must. Or we've got compliance wouldn't prejudice the lawful purpose of collection. And the one that I generally rely on in my legal opinions is it wouldn't be reasonably practicable in the circumstances to make the notifications. Again, think of the looting in South Africa at the moment. There may just not be time. It may not be reasonably practicable to go and make those notifications when we process the personal information. And at this point, I hand over to my esteemed colleagues to deal with the mine and health and safety legislation.
Right. Thank you, Ira. Yeah, thanks for all of you participating. And I will deal with the relevant legislation dealing with personal information. Now, we must consider the Mine Health and Safety Act, then other legislation being the Promotion of Access to Information Act, apart from POPIA. So if we look at the Mine Health and Safety Act, Nicole, if you can turn to slide 21. Now, Section 38 of the Mine Health and Safety Act, that's the most important and virtually the only one stipulation in the Mine Health and Safety Act dealing with private personal information. It says that you cannot disclose the personal private information of an employee to a health and safety representative or a health and safety committee. That is you as employer. The same applies to the inspector or a person who conducts an inquiry in terms of Section 65. But then Section 38(2) says that no employee may unreasonably withhold such consent. And then Section 38(1)(b) provides for a couple of exceptions. It says that the employer is not required to supply any information to health and safety representative or the health and safety committee if the information is legally privileged. And then further on, also if the employer, inspector or person could not disclose such information without contravening a prohibition imposed on the employer by the law or a court order, or the information is confidential, and if disclosed, may cause substantial harm to an employee or the employer. Now the question arises, what must you as employer or employee now do in view of all the legislation? You've got now the Mine Health and Safety Act on the one side, you've got POPIA, the Promotion of Access to Information Act, and you've got POPIA. If we look at the Promotion of Access to Information Act, then it provides for access to records of private and public bodies. I summarized very briefly the situation in regard to the access to private bodies' records. Section 2 applies to a request for access to the records of public bodies, and Part 3 to the records of private bodies. A private body may not refuse to disclose a record if it consists of information about an individual who has consented in writing to the disclosure. Secondly, which is already publicly available. And thirdly, about an individual who is deceased, and the requester is the individual's next of kin, or the individual's next of kin has granted written consent. So Nicole dealt earlier on with the situation of the personal information, the definition in POPI, that it relates to a living person or a juristic person. But here, of course, but it doesn't deal with the deceased, the information of the deceased. Whereas POPIA deals with, in section 63.2, deals with the information about a deceased. Usually what happens in inquiries and investigations in terms of section 60 and 65 of the Mine Health and Safety Act, there the consent will be requested of the next of kin before the information is adduced at the proceedings. Then POPIA deals with the various categories of information of a third party which is protected, being commercial information, confidential information, and legally privileged records. But let's go back and let's have a look at what do you do now when there are potentially three pieces of legislation impacting on the disclosure of information. Well, first of all, you look at the scope of the particular act that you deal with, whether it's POPI, whether it's Mine Health and Safety Act, or whether it's POPIA. Where a specific act is silent on a particular issue. For example, if we compare POPI with the Mine Health and Safety Act. Mine Health and Safety Act deals with very little, dealing with personal information is very scant, and I referred you to section 38. POPI deals with much more. But so if there is silence in the Mine Health and Safety Act, then you must go and look at POPI and, if applicable, to POPIA. Then what is the situation if there is some potential conflict between the two? Then you look at the application section, spelling out the scope of it. And in POPIA, you find section 5, which says this act, POPIA, applies to the exclusion of any provision of any other legislation that prohibits or restricts the disclosure of a record of a public body or a private body, and is materially inconsistent with an object or a specific provision of this act. Now you will find a similar provision in POPI. So POPI says in section 3.2, this act, POPI, applies, subject to paragraph B, to the exclusion of any provision of any other legislation. So other legislation being the Mine Health and Safety Act, POPIA, and so forth, that regulates the processing of personal information, and that is materially inconsistent with an object or a specific provision of this act. A lot of words, but at the end of the day, you must ask yourself, is this now materially inconsistent, yes or no? So if the Mine Health and Safety Act is silent on the issue, then of course, POPI must apply. And then secondly, if the other legislation provides for conditions for lawful processing of personal information that are more extensive than those set out in Chapter 3, the extensive conditions prevail. So and more extensive means if it's wider in scope, not if it's more strict or so, if it's wider. So if there are additional things dealt with in the other legislation, then you apply that. But of course, it mustn't now be materially inconsistent with POPI. So in the slides on slides 28 and 29, there I summarize how you should deal with the resolution of a potential conflict between the two, or what you may perceive to be a conflict, how to apply the particular legislation. Now, let's get to the Mine Health and Safety Act. The Mine Health and Safety Act deals with a very large number of matters where personal information is relevant. I've chosen a few. Firstly, the compilation of the annual report on health and safety, including statistics in this regard. That is regulated in section 21C, and you must process the information. So within the meaning of that's given to it in POPIA, you process personal information. It must be lawful. It is lawful because you must do it in terms of 21C. And then, what is also of relevance in this regard will be section 11 of POPIA, which says that personal information may only be processed if processing complies with an obligation imposed by law on the responsible person. So that's an important issue. And then also section 18.4. And a relevant factor which is taken into account when no notification to the data subject of the collection of this information that you compile now. A relevant factor there will be that, if the information will not be used in a form in which the data subject may be identified. So you shouldn't have a difficulty to compile your annual report if it doesn't refer to particular persons. If it does, then of course you go beyond the requirement of section 2, but there should be a justification, or there must be a justification if you want to go beyond that. So that's section 21C. Then secondly, if we can have a look at the requirement stipulated in section 8 to have a health and safety policy. Now, the health and safety policy may require processing of personal information. For example, the number of pregnancies on the plant, how many of those persons are restricted from going underground, and so forth and so forth. So you must ensure that you comply with section 8, read with the relevant prohibitions in POPIA, section 11, and then also, as Era has mentioned, the special personal information. Then, apart from that, section 10 of the Mine Health and Safety Act requires of the employer to record formal training information. That's a specific obligation of the employer. It must be recorded, and it must apply to each and every employee. So in terms of section 11(1)(c) and F of POPIA, you will be able to record it, and it will not be a contravention. The same applies to the recordal of significant hazards and risks in terms of section 11(1). Just as a background, in terms of section 11, the employer must conduct a risk assessment. They must identify hazards and assess the risks of the hazard occurring. And then if there is a significant hazard and risk, it must be recorded. And that recordal may involve particular employees or categories of employees involved in the particular health and safety situation. And again, reliance can be placed on section 11, section 18, and so forth of POPIA. Then when we deal with investigations and inquiries, in terms of section 11.5, the employer must conduct an investigation into a reportable accident, serious illness, or health-threatening occurrence, and must record it. So, again, you will rely on compliance with the law in order not to fall foul of any prohibition in POPIA. You will rely on section 11.5. Then, as a sixth item applicable to the Mine Health and Safety Act, the report of the reportable accident, serious illness, or health-threatening occurrence must be furnished to the Health and Safety Committee and the Principal Inspector of Mines. And again, the reliance can be placed on section 11.5E of POPIA. Then, in terms of section 12 and 13, the employer must record occupational hygiene and medical surveillance. So that will relate in many instances to a recordal of special personal information. And please keep in mind there that if no consent is required, then you must ensure that you fall under the escape clause referred to by ERA. And so you will have to rely on the particular legislation, this particular section in the Mine Health and Safety Act, which compels you to record these details. And also some of the other exceptions in section 18. Then those records must be supplied to the Principal Inspector of Mines, and then the employee is also entitled to such records. A very important issue is the question of criminal behavior referred to by ERA. And the question is, what do you do in an investigation and an inquiry where the evidence is that the employee has not taken reasonable care for his or her health and safety, or the health and safety of other persons, and as a result of that, an injury occurred to the particular employee or other employees? Can you, as the employer now, say to the employee, you were taught how to install underground support, and it is clear that you failed to do so on this particular situation. It was observed by the miner. You didn't do it. You were warned to comply with the rules. You failed to do so. Then a fall of ground occurred, which would not have occurred if it had not been for the insufficient support as far as density and quality and capacity is concerned. Can you now say to the employee, you failed to comply with section 22? Now, the contravention of section 22 is a criminal offense. In my view, you will be able to do so because that is in your own interest to show that you complied with the law, and also to comply with the obligation imposed by you in terms of section 22, read with other sections in the Mine Health and Safety Act. For example, section 2. Section 2 of the Mine Health and Safety Act provides that the employer must, as far as reasonably practicable, operate a mine with due regard to health and safety, which includes how employees deal with it, whether they trained, can they operate it with due regard to health and safety. The same applies to other possible contraventions like the damage of health and safety equipment and so forth. So although
Phil, I'm sorry to interrupt you. Just to add to that also, if you are processing special personal information, your red flag information, when you're doing these investigations or inspections and so on, please bear in mind that Section 27 of POPIA gives us a nice exception to process this red flag information. It says you can process it if it is necessary for the establishment, exercise, or defense or right or obligation in terms of law. So sorry for interrupting you there. I just wanted to add that POPIA gives us a nice exception to process the red flag information there, even without consent.
Yeah.
Back to you, Willem.
Yeah. So thanks for that, Era. Yeah, Section 27B says specifically that Section 26, that's the notification requirement, that or the prohibition, which is not applicable, that it says Section 26 doesn't apply if processing is necessary for the establishment, exercise, or defense of a right or obligation in law. Now, as I interpret it, that is the right or obligation in law of the responsible party. Do you agree, Era?
Yes,
absolutely. The data subject it refers to the responsible party.
Absolutely, Willem. I agree with you there, and we've got quite an interesting question here from a member of the audiences here as well, which I think relates to the same, and I would like to check that with you. It says, what happens if an employee passes on from COVID and the health team needs to share the information in order to do contact tracing of other employees who may be affected? There, the person that has passed on no longer has rights in terms of POPIA, because POPIA only protects you if you are a living human being. And of course, if we do contact tracing, again, in terms of another law that the responsible party must comply with, we could have done it anyway. So Willem, back to you.
Yeah, I agree with your observation. That is correct, because it is an obligation in terms of another law. So although it's quite a complex situation with different pieces of legislation which is applicable, it is something that people will get used to and that employers and employees should become acquainted with. I can just foresee that in investigations and inquiries, there are going to be huge disputes with the involvement of the inspectorate, and they may not be affair with the provisions of POPIA, and they may insist on consent in many of these instances, and if no consent is provided, then they're going to stop the person questioning the particular witness from asking certain questions and from putting it to the particular party or particular witness that he or she has contravened the law, where it is a defense of a right or obligation in law of the responsible party, being the employer or other party. But so the advice is that you as employer and other party participating in these proceedings should ensure that you know POPIA, the particular provisions applicable to mine health and safety, so that you can make prudent and proper objective submissions to the inspectorate so that they can understand what the situation is and why you may be able to put certain questions to a witness. Those are all my remarks concerning the application of POPIA and the relevant other laws to the Mine Health and Safety Act. Thank you.
Thank you very much, Willem. And I think just to recap from a POPIA perspective. So again, with POPIA, the first thing we say to ourselves is, are we processing personal information which is entered into a record? In the likes of an inquiry, we would definitely be processing personal information which is entered into a record. The second thing we ask ourselves, Is the information ordinary personal information, or is it our red flag information? If it is our ordinary personal information, generally, if we've got a lawful purpose, it's in our legitimate interest to do so, and so on, no stumble blocks in terms of POPI to process that information without consent. When we hit our red flag information, we're not saying you cannot process it. We're just saying that you need to be a little bit more careful when you process that information. So where you hit your red flag information, alleged criminal activity, health information, biometric information, and so on, it is nice to have consent, but if you don't have consent, and for example, there is a law that says you must process that information, then absolutely you can process that information even without consent. What we like doing from a POPI perspective, and Willem, I would like to hear your views on this. We like building in internal privacy statements at job application level already, where we tell people what we are going to do with their personal information. We get them to consent to our internal privacy statements. We do know, of course, they can withdraw consent, but then we are no worse off because we can still rely on those exceptions to consent. And for example, if we're processing information in terms of a law, they cannot even object to us processing the information in terms of a law. But what we're trying to avoid is the data subject saying they were surprised by us doing this with the information. So for that reason, we think there's a lot of value in having an internal privacy statement at job applicant level already, where we tell people exactly what we're doing with their information. And if we can, we get them to consent to that, because then we know we've got consent in the bank. Even though we don't always need the consent, it would alleviate us having to fight over our lawful justification to process that information in future. Willem, what do you think of the use of those sort of privacy policy, privacy statements in the mining environment?
I think it's very useful, but of course one must ensure that what the employee agrees to is very clear. It must be clear to the employee. If the employee is not if English is not his mother tongue, then it should be either be stated in his own or her own language, or otherwise you should make use of an interpreter. And the interpreter must then specify on the consent form. Otherwise, you're going to have huge disputes at the later stage that the employee didn't understand. It wasn't explained to the employee what he or she is signing. And so then you will be able to rely on the interpreter that can confirm it.
Yes, I think that's good practical advice in terms of POPI as well, because as you know, in terms of POPI, your consent must be specific and informed. So POPI doesn't tell us consent must be in English, Afrikaans, Zulu, or whatever language, but it must be specific and informed. So if a person doesn't understand what they are agreeing to in terms of POPI, we are never going to be able to say it is specific and informed. And then we've got a question, and to be honest, this is a bit Greek to me. Maybe Willem, you know what they are talking about. The DMRE have previously instructed companies to fully publish Section 11.5 reports to the general workforce. Ordinarily, these reports have personal information. Would it be advisable to depersonalize the reports when we publish them, i.e. removing people's names? These reports, can you shed some light on them, Willem? Do you know what this is about?
Well, firstly, Section 11 deals with risk management. As I said earlier on, the employer is obliged to identify hazards and to assess the risks of the hazards occurring. If there is a reportable accident, or there's a serious illness that occurred, or a health-threatening occurrence, then an investigation must be held in terms of Section 11.5. And at the end of that, a report must be completed, which must identify the causes and the underlying causes of the accident, serious illness, or health-threatening occurrence. It must also then make recommendations to prevent a similar accident, serious illness, or health-threatening occurrence. The Section 11.5D report, that need not identify the particular persons by name, But, to make any sense of it, you will have to stipulate at least the capacities of the persons, but there should be nothing wrong to stipulate the particular name of the employee. I mean, if you look at a team of workers, it may be anything between 5 and 20. So it will not make any sense if you describe it that the accident was caused as a result of a failure on the part of one of the employees to withdraw after a warning has been given of excessive methane concentrations and so forth. You will have to stipulate who it was. But I think that is required by the law. It's required by Section 11.5, because you must spell out the causes, the underlying causes, and you must make recommendations how to prevent a similar situation. So you must deal with the particular persons who were at fault or were involved in this situation.
Thank you, Willem. And I just want to address this now as well from a POPIA perspective. There's this misconception in the market that since POPIA came out, we are not allowed to use people's names. And I've seen some very funny memes in this regard as well. POPIA certainly doesn't say you cannot use people's names. And even if you had to depersonalize it by removing a person's name, if you had to speak to their capacity or their job title, that person may still be identifiable. So regardless of a person's name, we must still be dealing with personal information. Please also bear in mind that a name is not even red flag information. So if we have a lawful purpose, and it is, for example, in our legitimate interests or the legitimate interests of a third party, or there's a law that says that granular level of information is required, then absolutely we would be able to publish the information. If we can get around doing something without using personal information, it is of course safer, but where the personal information is required, then absolutely it could be used. Another question here, if during a meeting with various stakeholders and the employee consents to the release of their medical information in that inquiry, does the employee also need to sign for the release of their personal information as well? What you are asking about here in terms of POPIA is further processing of information, and that is where Section 15 kicks in. And anything that you do with personal information after you collected it must be compatible with the reason for collection. So if you are going to release that information to third parties, it would be safer to get a consent to do so unless you are required to do so in terms of law. You say here, must a form be signed for consent in terms of POPIA? There is no need to sign a form. Consent in terms of POPIA must just be voluntary, specific, informed, and an expression of will. But of course, signing a form is easier to prove, because you will remember just now I said, if you rely on consent, you are going to have to prove that you did obtain consent. Nicole, here's one for you. POPIA requires keeping... Sorry, Willem, go ahead.
Can I just mention that as far as the question is about an inquiry and the inquiry record. Of course, an inquiry is open to the public. So it will probably be regarded as a public record. And so on that basis, further consent should not be required.
Thank you very much. I didn't know that. Thank you, Willem, for correcting that. And then I see we're already at 10 o'clock. Nicole, I'm going to give you one last question here. POPIA requires keeping data only for the time it is intended to be used. Health investigations come back years later to haunt us. Should these classified similar to medical surveillance records data? I think it goes to how long we can store this data, Nicole.
So again, remember, if you've got a valid purpose for having it, first we need to say to ourselves, how long does the law obligate us to keep it? And where we think there could be a risk of litigation or claims, we should also be keeping it. But remember, we should then be applying security safeguards, additional security safeguards onto that information to look after it. Peter, over to you. I think we're out of time.
Yeah, thank you to everybody that attended the webinar today. And then I see that there's also a number of questions that we have not dealt with. We will make sure that we get back to you. I know some of the individuals that have posed some of those questions, and we will revert to you so that we can also answer those questions. I just also wanted to say thank you to all the speakers, to provide such practical, insightful knowledge, in respect of the legal provisions. And I think it will make it much easier for us now, when we have to start to navigate our way, dealing with POPI, especially in the mining industry. We all know that if you're suddenly confronted by an inspector, you need to understand the legal provisions. And I think from that perspective, it was highly insightful to get the information from the speakers. So I thank all of you for attending, and I thank again all the speakers for sharing their knowledge with all of us. Thank you very much. Enjoy your day.